to go now. We just had a agent in here who had a question. So today we're doing the real estate condition report. Joni's gonna kind of take the reins on this, and just again, sort of like last week, we'll probably have the gift of time. This will probably only take about a half an hour to go through. So we can open up the remaining half an hour for additional questions on anything that you guys might have a question on, or of course about the real estate condition report. All right, so here we go.
Well, good morning, everybody, or good afternoon. I think we're right at the noon time. Nice to see you on this call. I appreciate it. I did contract training on the condition report in March of this year, and it did last the entire hour. So if you want something a little more in-depth conversation about this, or you think that you want to know more, you can either call Steph or call me about particulars with the real estate condition report, or you can just check out that YouTube video that's in compliance training, compliance contract training, in the resource page. And it's March of this year, called Condition Report.
After this, I will link you guys to the YouTube channel. We don't do that every contract training, but it's a nice reminder of where you guys can watch all of our training videos, team meetings, launch coaching videos. I mean, we house everything that we put on Zoom. So it's a fantastic resource. So, okay.
Well, the reason we're doing this again in May is because it is so critical right now. As Charlie mentioned in the meeting last Tuesday, there's more and more threatened lawsuits floating around the real estate world. Buyers antennas are up, sellers' antennas are up, and they're bringing in attorneys. And we've had a couple of situations where an attorney has been brought in regarding the condition report. And so we all, Steph and I and Charlie and Kimmy, all felt it was important that we continue to go over this important document and the way to use it with your seller. So basically, I'm just going to go through the front page. As Steph and I both admitted to each other, that as agents, there were times when we would sort of hand this over to the seller and kind of skip going over the first page. The first page really has all the meat in it, and that's where attorneys will look to confirm their position. So it's important that you understand the first page and that you put that importance onto your seller on what the first page reads, what it says, and what it means to the seller. So this is all about disclosure, and you cannot stress to your seller enough. More disclosure is better than less disclosure. In fact, more disclosure of more disclosure is better than disclosure. So the more your seller discloses, the better off he is. Anytime they try to mask or not talk about something that they know about in the house, or they don't think it's important, or they don't want to bring it up because they're afraid they'll scare off buyers, is putting them in a precarious situation if it goes to closing and the buyers then find out about these things. And they always will. They'll either find out about it by using the house, or they'll find out about it by a talkative neighbor who says, oh yeah, I saw the furnace truck in there all the time. And he didn't mention anything about the furnace in the real estate condition report. So it's best to be upfront and understand to your seller the importance and the safety of disclosure. The other sort of warning before we get going is this document is not for your hands at all. You are to keep your hands off this real estate condition report. You're definitely supposed to give it to the seller, talk about the importance of it, talk about disclosure, but you in no way can advise, explain, go through the different defects that are listed in this and try to analyze it or give advice to. It is something that really should totally come from the seller and the seller's awareness of their property. So I want to go through the first page. As I say, sometimes people skip it, but let's go through it and don't skip it. So it's a disclosure. It reads, it's a disclosure of the condition of that property in compliance with section 70202 of the Wisconsin statutes. That right there is important because this is a Wisconsin statute. This is not a real estate REEB rule. It is something that all people who transfer property in the state of Wisconsin are required to fill out. So as of the month and the day and the year, it is not a warranty of any kind by the owner or any agents representing any party in this transaction, and is not a substitute for any inspections or warranties that the parties may wish to obtain. So that's important to understand, that it's not a substitute for inspections, but sometimes a real estate condition report can have an inspection attached to it. So that is a definition of what this report is. It is a disclosure report. So we go down to the next little paragraph. A buyer who does not receive a fully completed copy, and the key word here is completed, of this property within 10 days after the acceptance of the contract for the above real estate property has the right to rescind that contract. Now, most of all of us, including our sellers, will understand the word rescind, and it means to pull it back, provided the owner is required to provide this report under Wisconsin statutes. So if the owner is required to provide this report and does not within the first 10 days after acceptance, the buyer has a right to back out. Other than that, you cannot explain anything else about rescission, because as our attorney told us, that is legal advice, and all we can do is reiterate this little paragraph and understand and have the seller understand that he has to get this report in a timely basis. Most times the reports are available in MLS before someone even writes an offer.
Mm-hmm.
So, oops, shouldn't touch. The next paragraph, it's notice to the parties regarding advice or inspections. Now, this is a sort of repeat of what I just said. Real estate licensees may not provide advice or opinions concerning whether or not an item is a defect for the purposes of this report. So you cannot say, oh, you don't need to fill that in. Oh, no, that's not important. Or don't forget to do this, or don't forget to say what you told me yesterday about your furnace. You may not, and those words are clear, provide advice or opinions. You cannot talk about what you think is a defect to them or not a defect. The parties may wish to obtain professional advice or inspections of the property and to include appropriate provisions in a contract. So that means you can attach an inspection, or you can use the defects listed in an inspection and make those part of the real estate condition report. You, again, not to describe or define what a defect is to the seller. And if the seller, someone asked the question the other day, what if the seller doesn't know? What if they don't understand what this sentence means or what this condition means? This is telling you right now, the sellers may wish to obtain professional advice and to include appropriate provisions in a contract, which means call somebody, call a plumber, see what that means if it's in that section. If it's talking about land use, call an expert in that situation. You, the agent, are not supposed to give your opinion on what it means. So now these are the critical kicks in this form, and it's something that you should be very aware of, and it's something that you must make your seller be very aware of. The seller should blow this off, and you should know what's in it. So the sentence, every line starts with buyer is aware. And this word, it means aware, means the owners have knowledge or notice of that. It doesn't mean actual knowledge. Actual knowledge is they actually have a report stating it. This is a less standard that means all they have to do is have knowledge of a condition or have notice of a condition. In this form, defect. Now here it defines what a defect is to the seller directly. You don't have to explain what a defect is, and you don't need to give your opinion on whether something is a defect, but it gives the three sections of the definition of a defect. It would have significant adverse effect on the value of the property, would significantly impair the health or safety of future occupants of the property, or that if not repaired, removed, or replaced would significantly shorten or adversely affect the normal life of the premises. That's what a defect is, and that you just point that to the seller and say, that's the definition. Exceptions. An owner who is now this is important.
A3.
Oh, excuse me. In this form, owner means the person or persons, entity, or organization that owns the above described real estate property. An owner who transfers property containing 1 to 4 dwelling units, including a condominium unit and timeshare by sale, exchange, or land contract is required to complete this report. Let that sink in, because it means the owner must complete this report. Except now there are exceptions. There's a misunderstanding with many, many agents, and Steph and I hear this or see this in our contracts quite often. Sometimes an owner or an agent thinks if they never lived there, that they are exempt from filling out this report. That's not true. The only exemptions are as an owner who is a personal rep, a trustee, a conservator, or a fiduciary appointed by the court, and who has never lived in the property. Say they are personal rep, that doesn't automatically exempt that if they lived in the property, maybe even as a child. Now they don't have that exemption as a personal rep or a trustee. But if they never lived in the property and are appointed by the court, a personal rep, a trustee, they are the only ones exempt. An owner who transfers property that has not been inhabited or transfers property in a manner that's exempt from the real estate transfer fee. That means a property that has not been inhabited, that means new construction. Nobody's lived there, not just the seller has lived there, but it's never been inhabited by a person. That property is exempt from filling out a condition report. The other exemption of a property is one that has been transferred, say, within a family, from a father to a son. They're not required to fill out the transfer fee, so they're not required to fill out a record. Those are the exceptions. Just because the seller never lived there doesn't mean that they're exempt. And again, we still continue to get questions about that, and that's important to understand.
I think the biggest myth on an exemption is a flipper. A lot of people
Right.
think that just because someone purchased a home and never lived there while they were making improvements to it in order to resell it at a later date is exempt from filling out a real estate condition report. That is not the case.
Exactly. And an owner who must fill out a condition report but never lived there might be best suggested to get a pre-inspection to actually have some information on the condition of that property and not leave himself wide open. And number 4, the owner represents to the best of the owner's knowledge the responses to the following questions have been accurately checked as yes, no, or not applicable, NA. If the owner responds to the question with a yes, the owner shall provide in the additional information area an explanation of the reason why the response. So any yes must be explained in the lines under that section. There have been times in the past where some agents, if it's not applicable or they're not filling it out, will cross off a whole section, a big X through the whole thing. That is considered an incomplete report and is still open to rescission by the buyer. So you can't put that big X there. You have to put yes, no, or not applicable on every single item on that list.
So they could just completely, like you said, rescind if the X is on every page, they could, and then those 10 days go by, they can just say, all right, nope, I'm good.
Right, because they did not get a completed real estate condition report.
Awesome.
Even if a seller, who I think is the biggest waste of time and relationship, puts no, 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 no on every item and signs it off. It's usually the situation the seller didn't even read it and didn't want to take much time doing it and just figured that that was all he was required to do. You better be really careful with that seller, because that's where failure to disclose comes into effect. And that buyer moves into that house and finds out that some of those no, 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 no's were yes, yes, yeses, and the seller didn't disclose. He may be primed for a lawsuit.
Another comment, another version of a real estate condition report that's missing any answers, yes or no answers, it's also considered incomplete. So
Right.
let's say they filled all of it but 4 questions out. Those 4 questions make that report an incomplete report as well.
So it is your responsibility as the listing agent to review that real estate condition report before you put it out for agents to look or put it in MLS. You must do your due diligence in going over, make sure the seller didn't skip anything or just even accidentally miss a question. So to be considered, like Steph said, complete every line, every item has to be responded to. And this is interesting too. If the transfer is of a condominium unit, sometimes agents are confused of what they should be disclosing. You know, what if there's a leak in the garage where the cars are parked? What if the swimming pool hasn't worked in a while? In filling out the real estate condition report, the property to which this form applies is the condominium unit. The common elements of the condominium and any limited common elements that may be used only by the owner of the condominium. So there may be common elements in the condo, and if this owner is the only one that uses that condominium element, then he fills out a condition report regarding that issue. But basically, he only fills out elements that relate to the unit that he is in. So that's key to watch if you're listing a condominium. And then number 6, the owner discloses the following information. Now, this is where you really kind of drill it into your seller without being a lawyer. With the knowledge that even though this is not a warranty, prospective buyers may rely on this information in deciding whether and on what terms to purchase the property. The owner hereby authorizes the owner's agents and the agents of the prospective buyer to provide a copy of this report and to disclose any information in the report to any person in connection with any actual or anticipated sale of property. And before I go to the caution, this is another area where your duty as the listing agent comes in. Not only is it your duty to go over the condition report before you put it out to the public and see if you missed anything or X'd out anything, your duty as the listing agent is also to compare the way this has been filled out to what you actually have seen in the property. So if you've seen some actual situations that could be described as a defect and the seller has not marked that anywhere on the condition report, you can ask them why they haven't made a reference there. You can't advise them or give your opinion that it should be. You just ask them why it's not disclosed. And if it's something that you feel is an adverse defect, you have to, in writing, disclose that defect if the seller is not going to. Gets a little tense when that happens, but it is your duty as the listing agent to do so. So you cannot advise or give your opinion, but you have to review the record and you have to use your own eyes to see if you see any discrepancies from what the seller has said and what you have seen. So there's another little caution at the bottom of this. The list of defects following each question below are examples only and are not the only defects that may be property be disclosed in response. So if there's something else that is in one of these questions, it could be something that you have to add to the condition report. And as I said, if there's been a previous inspection on this property and the buyer walked because of the inspection, any defects cited in that inspection should be added to the condition report. It is important that the seller either attach the inspection or add the defects to an amended condition report.
Okay.
Excuse me. So any questions on that first page?
I feel like a lot of this next stuff will be repeats.
Yeah,
of what
this
we're
is
just
a
saying.
repeat. These next slides, 5 slides, I think, are from a team meeting I did, just a short basic version of what the property condition report is. And a repeat of what I have said, but it's an emphasis on what I think is the important things. That number one, it is required by all people transferring property within the state of Wisconsin. And the advice of legal counsel if needed, not you, not the agent. And the Wisconsin statute requires the seller to complete a record, whether they are broker assisted or for sale by owner, or risk rescissions of the offer to purchase. Our attorney, his advice to us was, you really can't go any deeper in this situation to explain what rescission means and the aspects of rescission. He considers that legal advice. And so we're really just stating to the seller that if you don't get this in on time, the buyer could walk if they don't get it completed. Sorry. And so again, notice that this is applies to all persons who transfer real estate containing 1 to 4 dwelling units. This is not for larger properties, but it does include condominium units, timeshare properties, and living quarters in a commercial property. So this is a reiteration of who is exempt. Again, it's reps, trustees, anyone appointed by the court, but only if they never lived there. If they live there, even if they are a trustee or a personal rep, the seller has died, they are still required to fill it out, even if they lived there 40 years ago as a child. This exclusion does not apply to powers of attorney. The other exemption is the real estate that has not been inhabited ever by anybody, and that's like new construction. It does not need a real estate condition report. Transfers exempt from the real estate transfer fee between spouses, foreclosures, probate transfers. Those transfers of property do not require a real estate transfer fee. Therefore, they do not require a real estate condition report. Now, I've had this situation happen with 2 of my listings, and it says if a seller is claiming he or she is exempt from completing it, the broker may review the WRA seller refusal statement regarding condition or disclosure report, that's in zip form, and ask the seller to complete the form. The form includes checkboxes identifying potential exemptions. So I had a seller, I have had 2 listings, 2 sellers. One of them, he bought a house to remodel and then put it on the market. It was a little more than a flip. But he never lived in the property. He had tenants that moved in there a couple of times, but he never lived there. So he didn't want to fill out the condition report. So I say to him as the agent, you are not exempt. You are still the seller. You have to fill out the condition report. And so he said to me, I don't want to fill out the condition report. And his point was, I don't want to be liable. I don't know what's been going on in that house. I've had tenants in and out of there, and I don't want to say what I know. I don't know really what it is. So I pulled out this WRA seller refusal. And one of the options that he checked was that he is aware that he is the seller of the property, but he refuses to fill it out. And when I explained that to the co-brokes who were showing the property, they understood. I mean, he's owned it for like 12 years, never lived there, isn't sure what's going on in the house, didn't have any inspections, and so therefore he's refusing it, and they took it. And they took it knowing it was sort of like an as-is, get a very good inspection. Yeah, Danny.
Is it then on, because I'm kind of in this situation right now. We haven't gone that far, but just in case it does. Is it then, let's say they do their refusal because they're not sure what's happened in the last 10 years, et cetera. Is it then on them to do an inspection, or is that, like you said, kind of like a risk on the buyers to do an as-is purchase?
Yeah, either way. I mean, it's not, they don't have to do the seller doesn't have to do an inspection, but it would be a good idea. I mean, I think it's a better idea, so he's not surprised when conditions on this property pop up. You know, he's prepared in advance on, does he want to sell it? He's made aware of some of these conditions, maybe he has the opportunity to correct some of these, and so risk not losing a buyer. He's not required to get an inspection. And a buyer, when he sees this refusal statement, is just treating it like an as-is. I better get a really, really good in-depth inspector to make sure I know everything about this house, because the seller's not telling me anything.
So then on the buyer's side, obviously it's super beneficial in that case. If they see the refusal, then to just get an inspection themselves.
Exactly. And one good question on this, and again, I'm not an attorney, so I can't give an opinion on this, is this considered failure to disclose when the seller fills out this refusal statement? And supposedly this WRA form protects the seller from failure to disclose, because he's saying, I put it in writing, I'm not disclosing anything. I don't know it, I'm not disclosing it. But that's an attorney opinion, and I would check with an attorney on whether or not that the seller did not disclose something.
And
So
actually,
it's not always necessarily a huge red flag. It's a matter of just them going, I don't know what's going on.
Exactly. And that was how I explained it to agents that were going to show it. And they were, all of them, I had another listing, the same thing. They were fine with it.
Okay, thank you.
So once the seller provides a real estate condition report, the licensee, and this is what I stated earlier, this is your duty to compare your observations and knowledge to what you're reading in his condition report. If there are inconsistencies or the licensee thinks the seller disclosures are incomplete or inaccurate, the licensee would make timely written disclosure of material adverse facts as appropriate. And there is a form for that. You must put it in writing, and you must give that form to anybody showing the property. So I think, yeah. again, as I said, if you want a more in-depth, kind of dragged out a little bit, but a pretty good review of this in more in-depth, go to the YouTube video in our resources at the homepage and look for the real estate condition report. It's an hour long and a lot of what I've said here, but there's still a lot more in there if you have more questions. But any questions, anything else? One thing that's also really good, and I'm not going to take the time to do this today, but not only is it your duty as the listing agent to go over that first page and understand, make sure that your seller understands the definitions of the disclosure report and what it means, but also you as the agent take the time to review every one of those questions on that form. Not necessarily with the seller, you are hands off in that sense, but for your own knowledge so that you can review the seller's version of the condition report, go over every single one of those questions. And I'm sure that you'll learn something by going over those. So it's quite in depth. It's been revised several times, and this latest revision of the real estate condition report even added more things. So it talks about the FERPTA and a lot of waterfront things if you're selling property on lakes or piers, land use. So make sure that you read it as well as import the distinction of this report to your seller and not let them mark no, 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 no.
Do you guys have any questions about this or any general questions? Okay.
No, you're all smart.
Next week, I think we have a guest speaker, Renee from Focus Title, who is our transaction coordinator. And we'll talk about contract to close processes, kind of what their role is and how in depth they go with contract to close assistance. So do not miss that. I think it's important to understand the contract to close process, but it's also kind of the details that bog you down and keep you from doing the things that are really fun about real estate, and that's making relationships and selling and buying and writing offers. So
Going to closing.
So yeah, it could be a tool that you guys would want to put in your toolbox later on as you guys get busier. So that's next week, and that's all we got.
And we're available.
Yep.
Thank you.
Thanks.
Thank you very much.
Bye.
Thank you. Have a great day.
Show me who's on here.
I am Cordell
Good.
and Danny.